Know that the Trust Indenture Act of 1939, speaking of securities, the Securities Act of 1933 and 1934 was not the first um, Securities Act. And so it's important to understand that the Negotiable Instrument Act, Bill of Exchange Act of 1881, as amended in 1882, is in fact the organic Securities Act, ladies and gentlemen. So that's really important to comprehend while we're going through this. This is part two. Exempted securities and transactions, section 304. Provisions of this title shall not apply to any of the following securities. One, any security other than a note, which would be a promissory note, bond, debenture, or evidence of indebtedness, whether or not secured, or B, a certificate of interest or participation in any such note, bond, debenture, or evidence of indebtedness, or C, a temporary certificate for or guarantee of any such note, bond, debenture, evidence of indebtedness, or certificate. Two, any certificate of indebtedness or participation in two or more securities having substantially different rights and privileges, or a temporary certificate of any such certificate. Three has been repealed. For A, any security exempted from the provisions of the Securities Act of 1933 by paragraph 2, 3, 4, 5, 6, 7, 8, 11, or 13 of section 3A thereof. B, any security exempted from the provisions of the Securities Act of 1933 as amended paragraph 2 of subsection 3A thereof, as amended by section 401 of the Employment Security Amendments of 1975. Any security issued under a mortgage indenture as to which a contract of insurance under the National Housing Act is in effect, and any such security shall be deemed to be exempt from the provisions of the Securities Act of 1933 to the same extent as though such security were specifically enumerated in sections 3A2 of such act. 6. Any note, bond, debenture, or evidence of indebtedness issued or guaranteed by a foreign government or by a subdivision, department, municipality, agency, or instrumentality thereof. 7. Any guarantee of any security which is exempted by this subsection. 8. Any security which has been or is to be issued otherwise than under an indenture, but this exemption shall not be applied within a period of 12 consecutive months to an aggregate principal amount of securities of the same issuer greater than the figure stated in subsection 3B of the Securities Act of 1933, limiting exemptions thereunder, or such lesser amount as the Commission may establish by its rules and regulations. 9. Any security which has been or is to be issued under an indenture which limits the aggregate principal amount of securities at any time outstanding thereunder to 10 million, or such lesser amount as the Commission may establish by its rules and regulations, but this exemption shall not be applied within a period of 36 consecutive months to more than 10 million aggregate principal amount of securities of the same issuer, or such lesser amount as the Commissioner may establish by its rules and regulations. Or 10. Any security issued under a mortgage or trust deed indenture as to which a contract of insurance under Title 11 of the National Housing Act is in effect, and any such security shall be deemed to be exempt from the provisions of the Securities Act of 1933 to the same extent as though such security were specifically enumerated in sections 3A2 as amended of the Securities Act of 1933, Title 15 U.S.C. 77CA2. In computing the aggregate principal amount of securities to which the exemptions provided by paragraph 8 and 9 may be applied, securities to which the provisions of sections 305 and 306 would not have applied, irrespective of the provisions of those paragraphs, shall be disregarded. B. The provisions of sections 305 and 306 shall not apply 1. To any of the transactions exempted from the provisions of Sections 5 of the Securities Act of 1933 by Sections 4 thereof, or 2. To any transactions which would be so exempted, but for the last sentence of paragraph 11 of Section 2, 1 of such act. C. The Commission shall, on application by the issuer and after opportunity for hearing thereon by order exempt from any one or more provisions of this title, any security issued or proposed to be issued under any indenture under which, at the time such application is filed, securities referred to in paragraph 3 of subsection A of this section are outstanding, or on January 1st, 1959, such securities were outstanding, if and to the extent that the Commission finds that compliance with such provisions or provisions through the execution of a supplemental indenture or otherwise, 1. Would require by reason of the provisions of such indenture or the provisions of any other indenture or agreement made prior to the enactment of this title or the provisions of the any applicable law, the consent of the holders of securities outstanding under any such indenture or agreement, or 2. Would impose an undue burden on the issuer having due regard to the public interest and the interest of investors. D. Commission. The Commission may, by rule or regulation upon its own motion, or by order of an application by an interested person, exempt conditionally or unconditionally any person, registration statement, indenture, security, or transaction, or any class or classes of persons, registration statements, indentures, securities, or transactions from any one or more of the provisions of this title, if and to the extent that such exemption is necessary or appropriate in the public interest and consistent with the protections of investors and the purpose fairly intended by this title. The Commission shall, by rules and regulations, determine the procedures under which an exemption under this subsection shall be granted, and may, in its sole discretion, decline to entertain any application for an order of exemption under this subsection. E. The Commission may, from time to time, by its rule and regulations, and subject to the such terms and conditions as may be prescribed herein, add to the securities exempted as provided in this section any class of securities issued by a small business investment company under the Small Business Investment Act of 1958, if it finds, having regard to the purpose of that act, that the enforcement of this act with respect to such securities is not necessary in the public interest and for the protection of the investors. Securities required to be registered under the Securities Act. Section 305A. Subject to the provisions of Sections 304, a registration statement relating to the securities shall include the following information and documents, as though such inclusion were required by the provisions of Section 7 of the Securities Act of 1933. 1. Such information and documents as the Commission may, by rules and regulations, prescribe in order to enable the Commission to determine whether any person designated to act as trustee under the indenture under which such security has been or is to be issued is eligible to act as such under subsection A of Section 310, and 2. An analysis of any provision of such indenture with respect to A, the definition of what shall constitute a default under such indenture and the withholding of notice to the indenture security holders of any such default. B, the authentication and delivery of the indenture securities and the application of the proceeds thereof. C, the release of or the release and substitution of any property subject to the lien of the indenture. D, the satisfaction and discharge of the indenture. And E, the evidence required to be furnished by the obligor upon the indentured securities to the trustee as to the compliance with the conditions and covenants provided for in such indenture. The information and documents required by paragraph 1 of this subsection with respect to the person designated to act as an indentured trustee shall be contained in a separate part of such registration statement, which part shall be signed by such person. Such part of the registration statement shall be deemed to be a document filed pursuant to this title, and the provisions of subsection 11, 12, 17, and 24 of the Securities Act of 1933 shall not apply to statements therein or omissions therefrom. B1, except as may be permitted by paragraph 2 of this subsection, the Commission shall issue an order prior to the effective date of registration refusing to permit such a registration statement to become effective if it finds that a. the security to which such registration statement relates has not been or is not to be issued under an indenture, or b. any person designated as trustee under such indenture is not eligible to act as such under subsection a of section 310. But no such order shall be issued except after notice and opportunity for hearing within the periods and in the manner required with respect to refusal orders pursuant to sections 8b of the Securities Act of 1933. If and when the Commission deems that the objection on which such order was based have been met, the Commission shall enter an order rescinding such refusal order, and the registration shall become effective at the time provided in sections 8A of the Securities Act of 1933 or upon the date of such rescission, whichever shall be later. 2. In the case of securities registered under the Securities Act of 1933, which securities are eligible to be issued, offered, or sold on a delayed basis by or on behalf of the registrant, the Commission shall not be required to issue an order pursuant to paragraph 1 of subsection B of section 305 for failure to designate a trustee eligible to act under subsection A of section 310 if, in accordance with such rules and regulations as may be prescribed by the Commission, the issuer of such securities files an application for the purpose of determining such trustee's eligibility under subsection A of section 310. The Commission shall issue an order prior to the effective date of such application, refusing to permit the application to become effective. If it finds that any person designated as trustee under such indenture is not eligible to act as such under subsection A of section 310, but no order shall be issued except after notice and opportunity for hearing within the periods and in the manner required with respect to the refusal orders pursuant to section 8B of the Securities Act of 1933. If after notice and opportunity for hearing the Commission issues an order under this provision, the obligor shall within 5 calendar days appoint a trustee meeting the requirements of subsection A of section 310. No such appointment shall be effective, and such refusal order shall not be rescinded by the Commission until a person eligible to act as trustee under subsection A of section 310 has been appointed. If no order is issued, an application filed pursuant to this paragraph shall be effective the 10th day after filing thereof, or such earlier date as the Commission may determine, having due regard to the adequacy of information provided therein, the public interest, and the protection of investors. C. A prospectus relating to any such securities shall include, to the extent the Commission may prescribe by rules and regulations as necessary and appropriate in the public interest or for the protection of investors, as though such inclusions were required by sections 10 of the Securities Act of 1933, a written statement containing the analysis set forth in the registration statement of any indenture provision with respect to the matters specified in paragraph 2 of subsection A of this section, together with a supplementary analysis prepared by the Commission of such provisions and of the effect thereof. If, in the opinion of the Commission, the inclusion of such supplementary analysis is necessary or appropriate in the public interest or for the protection of the investors, and the Commission so declares by order after notice, and, if demanded by the issuer, opportunity for hearing thereon, such order shall be entered prior to the effective date of registration, except that if opportunity for hearing thereon is demanded by the issuer, such order shall be entered within a reasonable time after such opportunity for hearing. D. The provisions of sections 11, 12, 17, and 24 of the Securities Act of 1933 and the provisions of sections 323 and 325 of this title shall not apply to statements in or omissions from any analyst required under the provisions of this section or sections 306 and 307. Securities not registered under the Securities Act. Sections 306. A. In the case of any security in which in the case of any security which is not registered under the Securities Act of 1933 and to which this subsection is applicable notwithstanding the provisions of sections 304, unless such securities has been or is to be issued under the indenture and an application for qualification is effective as to such indenture, it shall be unlawful for any person directly or indirectly, one, to make use of any means or instruments of transportation or communication in interstate commerce or of the mails to sell such securities through the use of medium of any prospectus or otherwise, or two, to carry or cause to be carried through the mails or in interstate commerce by any means or instruments of transportation any such securities for the purpose of sale or for delivery after sale. B. In the case of any security which is not registered under the Securities Act of 1933, but which has been or is to be issued under the indenture as to which an application for qualification is effective, it shall be unlawful for any person directly or indirectly, one, to make use of any means or instruments of transportation or communication in interstate commerce or of the mails to carry or transmit any prospectus relating to any such security, unless such prospectus, to the extent of the Commission may prescribe by rules and regulations as necessary and appropriate in the public interest or for the protection of the investors, includes or is accompanied by a written statement that contains the information specified in subsection C of section 305, or two, to carry or to cause to be carried through the mails or the interstate commerce or in interstate commerce any such securities for the purpose of sale or for delivery after sale, unless to the extent the Commission may prescribe by rules and regulations as necessary or appropriate in the public interest or for the protection of investors, accompanied or preceded by a written statement that contains the information specified in subsection C of section 305. C. It shall be unlawful for any person directly or indirectly to make use of any means or instrument of transportation or communication in interstate commerce or of the mails to offer to sell through the use or medium of any prospectus or otherwise any security which is not registered under the Securities Act of 1933 and to which this subsection is applicable notwithstanding the provisions of sections 304, unless such security has been or is to be issued under the indenture and an application for qualification has been filed as to such indenture, or while the application is the subject of a refusal order or stop order, or prior to qualification any public proceeding or examination under sections 307C. Qualification of indentures covering securities not required to be registered. Subsection 307. A. In the case of any security which is not required to be registered under the Securities Act of 1933 and to which subsection A of section 306 is applicable notwithstanding the provisions of section 304, and application for qualification of the indenture under which such security has been or is to be issued shall be filed with the Commission by the issuer or such security. Each such application shall be in such form and shall be signed in such manner as the Commission may by rules or regulations prescribe as necessary or appropriate in the public interest or for the protection of the investors. Each such application shall include the information and documents required by subsection A of section 305. The information and documents required by paragraph 1 of such subsection with respect to the person designated to act as indentured trustee shall be contained in the separate part of such application, which part shall be signed by such person. Each such application shall also include such of the other information and documents which would be required to be filed in order to register such indenture security under the Securities Act of 1933 as the Commission by rules and regulations prescribed as necessarily or appropriate in the public interest or for the protection of the investors. An application may be withdrawn by the applicant at any time prior to the effective date thereof. Subject to the provisions of sections 321, the information and documents contained in or filed with any applicant shall be made available to the public under such regulations as the commission may prescribe, and copies thereof, photostatic or otherwise, shall be furnished to every applicant therefore at such reasonable charge as the commission may prescribe. B. The filing with the commission of an application or of an amendment to an application shall be deemed to have taken place upon the receipt thereof by the commission. C. The provision of Section 8 of the Securities Act of 1933 and the provisions of subsection B of Section 305 of this title shall apply with respect to every such application as though such application were a registration statement filed pursuant to the provisions of such act. Integration of procedure with Securities Act and other acts when we come back. Bam.